and thank you for joining SERI's latest policy brief on adequate temporary alternative accommodation. So this webinar is proudly brought to you by the Socio-Economic Rights Institute, the South African Local Government Association, and the City Support Program. Before we start with our webinar, I think it's just good to reflect on South Africa's history and democracy, as it explains why we are where we are today. So it's been over 25 years since our democracy in 1994, but yet South Africa remains a country where extreme wealth exists alongside widespread poverty. This inequality is borne disproportionately by Black people, and it is as a result of South Africa's historical legacy and current exclusion from housing markets that the state has an obligation to provide alternative accommodation to occupiers who would be rendered homeless by an eviction. It is now more than ever, as the residents of the inner city buildings and the informal settlements experience the magnitude of COVID-19 pandemic. We are facing the consequences of inequality more than ever as a country. This webinar will reflect on the experiences and lessons from current alternative accommodation sites, and it will consider a proposed approach to municipal provision of alternative accommodation. My name is Khululiwe Bhengu. I'm an attorney at SERI and the facilitator for today's webinar. Joining me on the panel is Alana Porter, SERI's Director of Research and Advocacy. Alana will contextualize this policy brief in relation to the suite of research products that SERI has produced over the years. She will then be followed by Lauren Royston, a Senior Research Associate at SERI. Lauren will take us through the content of the policy. She will discuss an approach to municipal provision of alternative accommodation and the need for a national framework to guide municipalities. The person that will come after Lauren will be Usiyabonga Mahlangu, the General Secretary of the Inner City Federation and a resident in one of the temporary alternative accommodation sites. Siyabonga will share experiences of living in a temporary alternative accommodation site, and he will be followed by Sienna Nkahle, SALGA's Executive Director for Economic Development and Planning. I think it's also important to just mention that it's almost a decade since the landmarking judgment from the Constitutional Court in the Blue Moonlight case, where the court made it clear that municipalities must provide a temporary alternative accommodation where evictions will lead to homelessness. However, what we have seen over the years is that municipalities have been slow to develop a proactive alternative accommodation program in response to the case law. And this is also despite the Constitutional Court having further explained in the latter matter what alternative accommodation should not be. And also further litigation at the High Court level, explaining and thus reiterating that alternative accommodation in the shelters provided by municipalities is actually a home. And then after Siyabonga will be joined, sorry, I've already mentioned Sienna. So Sienna's input will guide us through SALGA and the municipalities' obligations. Okay. Hello? I think someone's mic is not on mute.
With SERI, I'm attending their webinar.
Okay, sorry about that. So lastly, we'll have Seth Maqetuga from Human Settlements Component Lead for the City Support Program. Seth will provide an input for us on what the law requires for metro municipalities in dealing with evictions and the provision of alternative accommodation. He will highlight tools available to metros to assist them to navigate through the emergency and medium to long-term development approaches. So each panelist will have strictly 8 minutes to give their input. And I just plead with you to stick to the 8 minutes because I will remind you as your time finishes. So please share your questions and comments in the Q&A option, and our panelists will reflect on those during the discussion time. This policy brief is available on our website, and the link will be posted in the chat box shortly. I think I will now hand over to Alana, who is our first panelist in this webinar.
Thanks very, very much. I think Ed has a PDF that he wants to put up on the screen. Ed is our Zoom master. And so he's handling the screen for anyone who wants to know. I'm also in charge of timekeeping. So if you get a WhatsApp from me, that's because I'm fulfilling my role. So my role this morning, as Kuliliwe said, is to contextualize the alternative accommodation policy brief relative to our other research products, all of which have been developed in close collaboration with our clients, in this case, inner city and informal settlement occupiers seeking well-located, affordable accommodation, and with housing and other relevant officials and practitioners, especially in the case of policy briefs. In 2013, SERI published 2 critical scene setting reports, one of which set out the jurisprudence, in other words, the law on evictions and alternative accommodation in South Africa, and the other, which was a research report which looked at quantifying the gap between low-income rental demand and low-income rental supply. The research showed that there was no permanent option available to people earning less than 3,200 Rand a month. In 2013, there was quite some strong scene setting happening in our research work. Our first community practice notes were published in 2014, and in this informal settlement series, which you can see at the bottom of your screen, we examined the strategies and tactics employed by community-based organizations and local leadership in 4 informal settlements to achieve tenure, security, basic services, and ultimately to fight for the in-situ upgrading of their settlements. The following year, in March 2015, we published Resisting Evictions in South Africa, which you can see in the top left-hand corner, a legal and practical guide which explains the rights of occupiers and the law regarding evictions and gives practical advice on how to resist them. And then later in 2015, we published our Inner City Alternative Accommodation Community Practice Notes series, which documented the history of resisting evictions and ongoing challenges faced by 3 communities in 3 relocation sites where alternative accommodation had been provided in the city of Johannesburg. And then in early 2016, we released the 2nd edition of our Housing Jurisprudence Report, Evictions and Alternative Accommodation in South Africa 2000 to 2016, an analysis of jurisprudence and implications for local government. This built on the 1st edition published in 2013, and it responded to the fact that despite years of litigation, and Kuliliwe has said this too, despite years of litigation and a host of progressive court judgments that have substantially contributed to the constitutional right of access to adequate housing, municipalities like the city of Johannesburg were still not fulfilling their obligation in relation to evictions and the provision of alternative accommodation. Later that same year, we published our first policy brief, and you can see that there on your screen, the Affordable Public Rental Housing Policy Brief, which advocates that a public rental housing program is needed to bridge the gap between the demand for and supply of affordable rental accommodation in higher density urban centers across the country. And then in 2017, we launched a new set of legal and practical guidelines on relocation to alternative accommodation to assist those involved in the relocation process to navigate the complexities involved in planning for and carrying out a relocation. The guidelines present an approach to relocations based on SERI's experience in planning and managing relocations to alternative housing and draws on international and local experience. They offered practical guidance on how to ensure that relocations are carried out in a way that respects the constitutional rights of the people being relocated. And then, not on your slide, but important, is the spatial mismatch report, Edged Out Spatial Mismatch and Spatial Justice in South Africa's main urban areas, which presented, and I think this is contextually exactly the point, it presented overwhelming evidence of unjust urban planning in South African cities, found that housing for the poor tends to be located far from job opportunities, which creates a poverty trap in which poor people are confined to living in areas which are least likely to provide them with an opportunity to get a job and to support themselves. It shows that South African cities are exclusionary spaces, but that properly regulated socially responsible development can help lift people out of poverty. Given the overwhelming evidence of spatial mismatch in this report, we called on all levels of government to intervene in housing and land markets and provide well-located and affordable housing for the poor. That this is central to dismantling the apartheid system and moving towards spatial justice in urban areas. So with that, I'd just like to say, yeah, thank you and welcome. We look forward to constructive and exciting engagement. And I'm going to hand over to Lauren to give a summary and overview of the alternative accommodation policy brief.
Lauren, your mic is on mute. I'm not sure if you're away.
Great start. Thanks, Kuliwe. I was not. So good morning, everybody, again. And thanks for the introduction, Alana. I want to start by way of introduction by setting out what SERI attempts to do with our policy briefs. It tends to be one of three things: either advocating for policy change, or for new policy formulation, or for improvements to the implementation of existing policy. This policy brief is about new policy formulation. We are trying to fill a gap that we've identified exists. Our policy briefs are informed by three things: the experiences of our clients in different contexts in South Africa, in this case, occupied inner city buildings and informal settlements. Secondly, the implications of our research findings. And thirdly, our litigation experiences. As Alana's just presented, this brief is informed by all of these. So how do we go about filling the gap? We review evictions law and its implications for municipalities. We set out a proposed approach to municipal provision of alternative accommodation. And finally, we discuss the need for a national framework. What's our analysis of the gap in a nutshell? Firstly, the law requires that municipalities provide temporary alternative accommodation when evictions lead to homelessness. Secondly, we've not seen proactive alternative accommodation programs in response to the law from municipalities. I know Seth and Siana will respond to this. Where accommodation has been provided, and there are cases where it has, the accommodation is generally compelled by court orders. We'd like to see that shift. In addition, where it has been provided, it hasn't been sufficient. Management has been a problem, and so have some models of provision, like the managed care model. And finally, in our analysis of this gap, the courts have not given content to what alternative accommodation. On the next slide, you'll see that what we do in the brief is address the context of occupation. Kulaliwe has already done that, highlighting the history of dispossession and apartheid and persistent problems that exist due to market exclusion. So I won't focus on that further. In terms of evictions law in South Africa, we look at three things. The first is the Constitution, in particular Section 26(3). The second is the PI Act, and the third is the case law. So as many people in this webinar will no doubt be aware, Section 26(3) prohibits arbitrary evictions, and it does so by requiring that evictions be authorized by a court order, taking into account all the relevant circumstances. And then the Prevention of Illegal Eviction from and Unlawful Occupation of Land Act, the PIE Act, was passed in 1998 by the first democratic parliament. It gave effect to section 26(3) by requiring that eviction of an unlawful occupier must be just and equitable. I think it's important to mention and to remind ourselves that the PIE Act was intended to protect the millions of South Africans in urban areas who at the time had no common law entitlement to the land that they lived on. The intention of the Act was in part to change the apartheid legal framework, which targeted unlawful occupation and land invasion, to a framework that seeks to prevent illegal evictions. And I think that point is particularly relevant at the moment. So the legal framework establishes that an eviction order may not be granted if an eviction would not be just and equitable. Finally, eviction law has been developing over the past 20 years through litigation. In essence, and the brief addresses this in more detail, as does our review of the case law, another report that Alana mentioned. The essence of this litigation is that when eviction leads to homelessness from public and private land, in the inner city or in informal settlements, municipalities have an obligation to provide adequate temporary alternative accommodation. So on the next slide, we set out in brief the implications of this law for municipalities. Our starting point is to advocate that a municipal approach to alternative accommodation should take the implications of the case law, the PIE Act and Section 26 as a starting point. What does this mean? Firstly, municipalities must adopt a reasonable housing policy. Secondly, they're required to meaningfully engage with the parties to eviction proceedings. Thirdly, municipalities must be joined to eviction proceedings where the occupiers who face eviction will become homeless. Next, municipalities are also required to place sufficient information before a court for the court to do its job of making a decision about the relevant circumstances and whether an eviction would be just and equitable. And it's on the basis of this requirement that our recommendations about planning are made. And I'll come to that in a moment. And finally, given blue moonlight, it's clear that municipalities are also obliged to budget. So having said all of that, on the next slide, you'll see the content of the proposed municipal approach that we advocate for in this policy brief to fill the gap. There's no time to go through all of these, but I'd like to just identify what the elements of the proposed approach are and focus on the first and the last in a little bit more detail if I have the time. So we set out an approach to planning for alternative accommodation. We identify that meaningful engagement is a requirement, and we address what the purpose is, what the content is, and when meaningful engagement should take place. We look at the question of adequacy, and I'd like to reflect briefly on that if I have the time, because this is where the courts have not provided substantive guidance. Instead, they use a standard of reasonableness. So the municipal approach needs to meet that standard of reasonableness. We look at duration, qualification, and some key definitions, including the definition of family. We look at how relocation and alternative accommodation processes should be initiated or activated, arguing that we really want a proactive approach that permits more than a litigation process. So we're looking at ways that occupiers could initiate, and we're looking at ways that municipalities can proactively plan. We look at development, management, and maintenance, noting that management and maintenance have been key problems for people living in occupied, in relocation sites. We make mention of the budgeting and funding requirements, and we end with permanent housing assistance. In short, the planning component is to promote this proactive programmed approach, which we think is required and which would be compliant with the Constitution. We're hoping that municipalities through this approach would provide alternative accommodation without being compelled to do so, and without people, occupiers, needing representation, legal representation at all time. In the planning proposals, we align what we're proposing with the categorization of informal settlements that is proposed in the NASP approach. And we particularly focus on the relocation categories. Regarding adequacy, we look at the guidance provided by a range of sources: emergency housing program, case law, Joe Slovo and Gladler in particular. We look to the extension of Security of Tenure Act to see what it has to offer us. We also look to international guidance on adequacy that is also available. Finally, we draw on our research into the lived experiences of relocated people and what it demonstrates. And in summary, dormitory rooms expose women and children to gender-based violence, couples to a lack of dignity and privacy, children to sexual activity of adults, and everyone to threats of fire. We're saying rather than exacerbate the vulnerability of people who are already vulnerable, alternative accommodation really is intended to mitigate it. Adequacy needs to address building specifications and standards, appropriate procedural requirements pertaining to things like site inspections, building management and maintenance, and tenant committees. We address these in one of our other products, which Alana mentioned, the relocation guidelines. Permanent housing assistance is important because we all know that temporary alternative accommodation becomes permanent due to the unavailability of affordable permanent options, which are the reason in the first place that people occupy out of desperate need. However, if accommodation is designed and managed as temporary and it then becomes permanent, we're seeing maintenance and regulatory problems arising. So access to permanent accommodation is of critical importance. We're saying municipalities should play an information and facilitation role to assist relocated occupiers find affordable permanent housing, such as assisting occupiers with housing applications. Finally, on my last slide, we identify the need for a national framework. It should clarify the legal framework and the role of municipalities. It should establish principles not only for provision, but also for maintenance. There are a few definitions that require unambiguous clarification, such as terms like meaningful engagement, informed consent, family. The national framework should also guide the alignment of municipal alternative accommodation planning with existing planning instruments such as SDFs and IDPs, and it should also provide institutional and operational support using existing instruments, the Social Housing Regulatory Authority, the National Upgrading Support Program. In conclusion, we end this section with some reference to terminology. I'll focus just very briefly by way of conclusion on transitional housing. The national framework, we're saying, should have a clear and specific focus on homelessness that results from evictions. This is what temporary alternative accommodation is. Transitional housing and alternative accommodation have in common their temporary nature, but the notion of transitional and temporary are not quite the same, and we draw attention to that. We're saying that if municipalities use transitional housing as alternative accommodation, then they must ensure that the accommodation is constitutionally compliant, including the house rules. Gladler shows us that daytime lockout and gender segregation are unacceptable standards in the adequacy measure. So that's my last slide, and I'm going to hand over to either Kuliliwe or Siana. Thank you.
Thank you very much, Lauren, for that. We have Siyabonga Mahlangu coming up next as the person who lives in a temporary alternative accommodation site. But just before I hand over to him, I just wanted to comment on the part of meaningful engagement and how it's very important to continue to have meaningful engagement with occupiers, even post the relocation. Because our experience at SERI has been that communication or engagement that stops at the relocation, and it becomes a problem for the occupiers who are at these alternative accommodation sites as they experience difficulties and there is no engagement from the municipality's side, and they often have to do that through attorneys, which is not desirable. And I think this is a very nice introduction to what Siyabonga will say about his experiences living in the alternative accommodation sites. So I'll hand over to Siyabonga Mahlangu.
Thanks, Khululiwe, to give me a chance to give that experience, how it feels to live in alternative accommodation, especially that is being provided by the City of Johannesburg. To live there, it's not nice. I rather prefer to stay in the occupied building because of the things that are happening there, which are taking place, which we feel that they are not right. When they do the relocation, they will take you where you sit and you take that place as a home. They will relocate you to that particular building, whatever building it can be called. They will dump you there without telling you, if you've got this problem, this is the right person to approach so that your problem will be solved. As we are talking now, where I reside, we're having the problem of the pipe leakage, the storage we're running inside the rooms where we are staying. We tried so many times to do a communication with the city. They didn't do anything. We end up popping our own money to maintain that thing that was happening there. So I think Roland touches the main important point of meaningful engagement, whereby the city has to give us the chance to engage with them without involving any legal representative, so that we prevent wasting time for something that we can resolve without going to court, without approaching any legal representative. But the city denies us to have that chance with them, because when you talk to them, they'll say, you know where you have to report to. You've got the attorney that it's a part and parcel of this particular case. So please engage with your attorney. Your attorney will come to engage with us, which is something that doesn't make sense to us, because we treat those places like our home. Whatever things that is happening there, we are concerned about it. We are willing to help. We are willing to be part of that thing without involving the legal teams that they are representing us. In most of the alternative accommodation that is being provided by the city, they are doing the same thing. I can mention many of them. I saw one of them which was appearing on Lauren's screen, which is on GP's side. They are doing the same thing. Even today, they are still fighting for that the place must be maintained, the place must be looked proper. The residents, they are willing to take part to participate in maintaining the building, but it's just that they don't have got such much funds to do those things. And we are keep on asking ourselves those questions. Are these places being funded? Is there any fund from the government to maintain this particular alternative accommodation? Or we have to see for ourselves, how do we maintain them? But we don't get answers from the city. Instead, we are being pushed away if we ask such questions from them, which is things that I really want to see it one day changed. We want to see those places being attended properly, like other places where government officials are being seated, because we know that in the places that they are being government officials, they are well maintained, they're being taken care of, but where the ordinary resident they are residing, they don't care. They just dump you there, then they go for years. Then after that, they will come and say that we are trying like to vandalize the place, which it doesn't make sense because we can't, no one has to vandalize the place that he or she called it a home. So for us, that thing doesn't make sense, which I think the city has to change their policies or their implementations, because I think the most important thing is on the implementation. What I can say when it comes to those alternative accommodation is like they are making a favor to put us there. That's why they are always saying that they want to be compelled by the court what to do, while they've got a constitutional obligation, which is something that doesn't even need a court to entertain and to intervene on it. They have to perform their duties so that everyone, they should be treated equally, not unequally. That's what I can say in that particular time. I would like to hand over back to Khululiwa in this time.
Thank you, Siyabonga. What Siyabonga has just explained to us has been something that most occupiers who reside in these TEAs provided by municipalities have expressed, at least in the matters that SERI is dealing with. But the common thing amongst all occupiers is that it seems as if the city has just dumped people there to see for themselves what to do, because unfortunately they have been ordered by a court to do so, which is it touches on many violations of people's rights. In some cases, their rights to access to water and all of those things. I think this is a better time for us to have Sienna come in from SALGA to discuss the municipal obligations, and maybe we just get to have a view of the municipality side and not just the view from the occupiers' sides, and we can engage on that discussion later on when we have a Q&A. Over to you, Sienna.
Hey, good morning, colleagues. Am I audible?
Yes, we can hear you, Sienna.
Okay. No, thank you very much for having me on the program. I didn't quite get who is in the room, but where I come from, at least in part, there's protocols allow me to greet everybody with the due respect that they all deserve, and not go into the nitty-gritties of the protocols. Having said that, I think it might also be useful to clarify a perspective that I am here. Indeed, I work for SALGA. I am not sure I am sharing a view of the municipalities or sharing a view of a system. And I clarify that in the context that I wear multiple hats. One of those hats is working with an NGO that has a history of managing and supporting the most vulnerable members of our community prior to '94 through that transition up to now. And I think it is important to highlight that dual role in my engagement, because I want to position it in the context that moves away from pointing fingers at one another as to who is doing what, who's not doing what, and rather look at a system that indeed is crying out for improvement. There's certain things, there's many things that have gone well. Equally so, there's many other things that have gone wrong. In some instances, have gone horribly wrong. And I think the conversations that you often have in the public domain about throwing stones at each other, about who has done what, at times become a race to the bottom. And that is notwithstanding that as part of fixing a system, we equally in that process need to strengthen ways of holding each other accountable. So when I say we shouldn't point fingers at one another, I think we do need to continue to strengthen accountability and in fact consequences. I have a strong belief that we haven't done particularly well in meting out consequences for those who have done a disservice to the system as a whole, and most importantly to the most vulnerable in society. Having said that, I actually would like to appreciate two things. In fact, maybe three. I would like to appreciate SERI for having done this piece of work. I think it is an incredibly useful piece of work. We have worked with SERI on numerous occasions previously, and while in some of those engagements, it has made for some often difficult conversations, at sometimes awkward conversations between SERI and ourselves as officials, and at times even with our member principals who happen to be mayors from different municipalities across the country. But sometimes those honest, open and frank conversations are useful if we are to have any shot at fixing the system. So thank you very much, SERI, for doing that. The second thing is I would like to also agree, Lauren, with I think what was on the last slide, that proposes that we need to hold hands together in developing a national approach that we can all jointly contribute to, in co-creating and presumably also in implementing. And that for me is the focus of my discussion. Within that context, perhaps the last thing, the third and the last thing that I would then want to appreciate is that while the piece of work is based on case law or jurisprudence, that we reserve the right to litigate whenever that need comes. But what I am indeed appreciating is that the litigation does indeed become a measure of last resort. And that is what I'm anticipating the national framework, which we would be very happy to contribute to and work towards, even in mobilizing within our member community, as in municipalities, technical, administrative, and councillors, political representative, and so on. I would be very keen to facilitate a series of conversations that firstly identifies what needs to be done. We could even have a further set of conversations to reflect on what should and shouldn't have been, even if it includes pointing out some of those gaps and things that have not gone particularly well. So I upfront offer myself and of course the team that I represent to work together with SERI to continue to refine this piece of work. Having said that, I would like to acknowledge, or for all of us to acknowledge in the pursuit of that overall approach, that it's a difficult journey. I'll make an example with the city of, or maybe Gauteng as a whole even. In Gauteng, there are almost 300,000 new residents that come into the province annually. Now, if you consider the fact that that is the number of some cities in some parts of the world, the whole city that has existed for decades, and the plan for that 300,000 people is something that spans many, many years. In the space that we are in, we have to plan and adjust those plans with that moving target. So how do we, one, acknowledge that indeed a large number of houses have been built? And I'm talking even permanent houses. I understand that part of the conversation now is to find temporary accommodation or transitional accommodation for, in particular, people that have just been evicted. And that is entrenched in law. And a law that we wholeheartedly support. It's a difficult one. We would have preferred that it does not bestow the responsibility of that alternative accommodation to municipalities, considering the fact that the delivery of housing is a responsibility that sits somewhere else. It's a concurrent function, and that is a conversation for a whole new event altogether. But if you consider the fact that it has happened, we have to accept it, because we have to accept the Constitution, we have to accept the law. But having accepted it, can we then work together in refining the system in such a manner that it enables Gauteng to accommodate these 300,000 extra people annually, whom we have taken a posture as perhaps as a province there in Gauteng, but also as a country that everybody has the freedom to move everywhere that they want to, and in fact, wherever they are, they have a right to decent accommodation. The modalities of delivering on that constitutional obligation that all of us co-created, I think, is a subject of that national framework that I think we do need to develop. I would like to culminate with, is it about 4 quick pointers, and they will be quick. In that I have worked with SERI, I know SERI's strength, and I respect that strength, and I would like for us to work together in looking at revising and refining the overall picture. Part of that is, can we empower the system there where it delivers, such that it can be able to deliver well? We've spoken about the councillors, and I think the experience of the colleagues around the room saying that they haven't received much joy from either officials or councillors in the municipality, and City of Joburg being a particular case in point, when we have argued that perhaps you need to devolve this function of delivering housing such that it can be integrated into the overall plans and budgets and oversight mechanisms of the city. There was a lot of progress for a while, with support being provided for municipalities to build the capacity to deliver housing. And then at some point, that reneged. When it reneges, that capacity to do some of these things which we are agreeing must be done, then stalls. When there is no capacity, unfortunately, those who suffer the most are those who are the most vulnerable in our society. And yes, we can litigate, which is an instrument that we have reserved the right to utilize. But if there is no capacity, whether it is human capacity or financial capacity or whatever the case may be, we'll litigate, we'll find the city guilty, but it may not necessarily address the problem, at least in a sustainable manner. You may then find a situation where those who are on the receiving end of that judgment then comply with the judgment just for compliance sake. And I say this very cautiously, because it should not happen. In fact, we should be even more proactive. And I agree wholeheartedly about what the recommendations are, that we need to plan and budget accordingly. That is a proactive approach that does not wait for the litigation, which litigates in an instance where the solution might not be sufficient. So that's one. Secondly is in the integrated, or in that overall approach and the planning, we ensure integrated planning. Part of that integrated planning itself includes participation, and I think the word that was used, which I also agree with, is meaningful participation. It is also very unfortunate, and I will take part of that responsibility as perhaps individuals and as the institutions that I come from, that in many instances that participation has been far from ideal. Having seen many parts of the world, there's very few countries in the world that have legislated participation like the way South Africa has done. So it is in the law, it's in our policy, it is in our institutional makeup, but we're struggling to get it right. So I couldn't agree with Siyabonga more that can we please get this engagement right? I'm not saying that anybody in the room here provides an answer for that. I'm acknowledging a flaw in the system, that while we have designed probably the best system in the world in as far as policy, law, and institutions, when it comes to the execution, there's a different ball game altogether. Third is another thing that which is actually incidentally in the public domain currently, is a review of the securing tenure rights, such that we manage this challenge also upstream before the eviction happens. So there is a process currently that is underway. There is a bill that is on the table, Ultra. I think Ultra is upgrading of land tenure rights. Can we work together, certainly with SERI and the other colleagues that are around the table that can make some meaningful insights into that, so that we manage this challenge across the whole value chain. I will not talk about at length about reviewing the fiscal system, because every time we talk about money, some of the first questions that come is that money comes and goes right down a bottomless pit. It is true in some instances, not always true in certain instances, but it makes for a very uncomfortable, awkward conversation. Maybe a very last point, therefore, is that as we overhaul the system, including building that capacity, devolution, reviewing of the fiscal system, building the capacity at the municipal level, we also need to be cognizant of mitigating against the risks that are inherent in this environment, both at the municipal level and across other spheres of government. A big part of that is the plague of corruption, mismanagement, maladministration. That while I will indeed continue to advocate for a review of the institutional mechanism and in fact a review of the fiscal system such that the municipality has slightly more levers to deliver on the expectation that you all agree must be done, we do need to plug that tap of corruption and a drain in the system of finances of the citizen of the country. We can, in fact, I would like to have a conversation with SERI in a different context around how we can manage the implementation of an accountability and consequence system, which we have initiated for the local government sector. The implementation is proving a bit difficult to land. There are some areas where there is some good traction, but upscaling it, I think, requires a lot more interrogation and thought, and I welcome conversations from various colleagues around the table in the journey to refine that. the other element of risk that we do need to be cognizant of and plug is the capacity and the capacity to spend. Some municipalities have spent their housing grants, the USDGs. Others have struggled to do that. And if you struggle to spend, then you'll have some of these challenges that we're talking about now. So if we can be able to manage the corruption and the maladministration and plug the gap in the capacity of our institutions across the board at the municipal, provincial, and national level, I think we can be able to avoid the kind of difficult conversations that we're having now. Of course, I speak through the lens of the municipality on the other hat that I'm wearing, but we need to be cognizant that when the municipality fails, the same constitution says that, in fact, you as a province and as a national government, you have failed, because section 154 of that constitution says that when you see red flags in the municipal environment, provide support. So when we have failed to provide that support, and indeed that municipality then collapses, then it is a collective failure. That is about that particular clause in the constitution. The white paper on local government speaks about cooperative governance, which is ensuring that we govern collectively between the state and other social partners, including civil society. When there is a failure in that overall system, there is parts of that failure that we all equally need to take responsibility for. And it is in that context, perhaps, that I sign out in saying that let's work together in developing and implementing that overall national approach, which will hopefully help us to avoid litigation. But of course, leaving it as an instrument to those who want to pursue that route. It is their right. We need to defend that right of theirs and support them in whatever mechanisms that they may need support on, should they choose to go that route. But I still want to see it as a measure of last response. Thank you very much.
Thank you very much, Sienna, for that. I think because of time, we will just move to Seth, and then we'll have the Q&A session thereafter to discuss any issues that arose out of the discussions that the people who have spoken have highlighted, both from the municipality side as well as the occupier side and SERI side, of course. So Seth, over to you.
A very good morning, colleagues, and to everybody who will be watching today. And please accept my apology for using the phone. I'm having problems with my computer, and so I had to change now to the phone so that you can be able to hear me. I'm representing the City Support Program from National Treasury in the Intergovernmental Relations unit. And what I'm going to be saying, as Sienna has also indicated, whilst our purpose and our mandate is to support the cities in policy, in fiscal policy, and also in capacity, support, I cannot sit here and say now what I'm going to be saying, is representing the cities. But all I can say is that as the City Support Program, our main aim and purpose basically is to support the cities whom we regard as the engine of growth, in our countries, and to be able basically, to promote and facilitate inclusive growth through inclusive and sustainable development, within their city. And so our key focus is more on city, development. Regarding our approach then, we basically use about 4 windows in supporting the cities, and one of those windows being that of economic development, climate resilience, a good governance, and then public transport, as well as sustainable human settlements. And so I am representing the human settlements window of the city's support program, whose one of its objectives is basically that of informal settlements upgrading support to the metros. And what we have done over the past 2 years, we have basically, what we have done over the past 2 years, we have gone to all the 8 metros, just trying to identify what were the key barriers towards citywide and programmatic upgrading. And on the basis of that, we were then able to come up with a programmatic mechanism and toolkit to support the metros to address the issues of informal settlements upgrading, in their city. And we have done that work working very closely or in collaboration with the National Upgrading Support Program, who is NASP. In fact, even in our diagnosis, just identifying the barriers, in the cities, we were doing that work collaboratively with NASP. But in terms of our discussion today, I think in terms of the case law with regard to alternative accommodation, it's a principle that we are in full support of it, that the cities have got to be, proactive, and they've got to plan, in fact, proactively with regard to alternative accommodation, or alternative accommodation is supposed to be an integral part of citywide programmatic upgrading, in our cities. It's something that we are promoting, as the cities support program. Equally, we are also saying that the cities cannot be able to fulfill this responsibility on their own. They will require an enabling environment for them to be able to fulfill this responsibility. Thus saying that your proposal basically for a national framework to support municipalities as well as the metros in fulfilling this responsibility becomes very important. One of the areas that we have identified in our city support, framework, in terms of supporting the city to be able to fulfill this responsibility. In fact, the focus area has been that of the cities need to get ahead of the game. They need to be ahead of the game. And so in a way, in your language, they need to be proactive, basically, in terms of citywide programmatic, upgrading. And on the barriers, in terms of this getting ahead of the game or to citywide upgrading, the cities in our scoping have indicated that the issue of urban migration, the issues of land invasion is one of the biggest challenges that they are facing as the cities. And a challenge basically that they are not able to deal with it on their own. They require support for them to be able to deal it on their own. And so the mechanism and the toolkit that we have developed in collaboration with the National Upgrading Support Program, it's basically aimed, to support the city to be able to deal, how do we deal with the issue, of invasions, of relocations, and the issue basically of alternative, accommodation. What the toolkit basically proposes, I'm just going to be touching on the principles here. The first principle is that of responding to urban migration, because the issue of alternative accommodation at the core of it is the issue of how do you manage urbanization. And one of the principles is that urban migration, it's a national issue and it requires an multidisciplinary team in its approach, where a national government, a provincial government, as well as the municipalities basically work together to find a solution that is sustainable to the issue of upgrading informal settlements, and then also to be able to deal with the issue of alternative, accommodation. And so the issue of resources, the issue of capacity, it always remains a challenge at a city level. Hence, then they require that integrated or multidisciplinary, approach. And so we've got to look basically at a different institutional framework when it comes to addressing the issue of informal settlements upgrading and also addressing the issue effectively of alternative, accommodation. Whilst we agree with the case law that the primary responsibility is at the city level, but they cannot do it on their own because of limited resources and because of limited capacity. They've got to be supported, and there's got to be a very effective institutional framework between the spheres of government. The second issue is the issue of common understanding of migration and the pressures that the cities are having when it comes to the issue of invasions, the issues of relocations, and the issues of land. If you look at the cities at the present moment, when you start to talk about the issue of alternative accommodation as well as growth that is happening within their city, it's something that sometimes they just avoid, and that is a problem. Whereas when you go to the national and provincial sphere of government, they see urbanization and migration as a reality, and it's something basically that we need to work around so that we can be able, to see it as an issue that promotes socio-economic development, within our city. And so that common understanding between the three spheres of government will help in coming up with a policy, basically, that responds effectively on the question of urban migration, on the question of how do we become proactive in terms of these relocations, as well as providing, alternative, accommodation. If we see urbanization, we see urban migration as the problem, then our policy becomes problematic, in the end. And so that common understanding between the spheres of government also then becomes, important. And then the third principle that I want to share as well is the principle of the quality of scale of future migration. I think at the present moment, there has been more focus in dealing with the current, program, which is also a very important things in terms of supplying, housing, be it social housing, be it BNG housing, be it CRU housing, as you correctly say, and not planning basically for any possible or potential evictions that may happen, or people that may need to be relocated, so that we also start to be planning, for that. Whilst the cities, we're beginning to see them doing some predictive modeling in terms of the growth in their cities, we need to support the cities more, basically, also to be coming up with the mechanisms now of how do we manage that growth now, and how do we ensure that as the city is growing, we are also able to accommodate people or accommodate the growth, within their cities. We need to be increasing basically our scale in terms of those predictive, modeling, so that we can be able to effectively address the issue of, growth in our cities. And then the other point, we also need to understand the migration choices. Why are people basically, are moving into our cities? Why are they going to where they are, are going, And we need to understand the supply mechanisms as well. Why are people, are going to informal settlements? Why are they going to backyarders? And once we have a better understanding of those trends, then we'll be able, to come up with mechanisms and strategies that will be able to support, the cities. And so in a very specific terms, then what we are trying to promote within the toolkit in addressing the barriers that the cities basically have indicated is that we believe strongly that there is a need to pay more attention on managed land settlements, basically, where we can be able, to accommodate and to manage the growth that is happening within the city. It's a policy, or it's an issue that we have been discussing, and it's also even a tool that I think organizations like Ephesus or Corpus Ephesus have developed the tools. But I think it is high time now that we begin to really start to be piloting, such initiatives, and see how managed land settlements can really start to be working, within our cities. We're also promoting basically the provision of service sites, so that we can be able to accommodate growth within our city. But with the approach of service sites, it cannot just be the pipes and the water and the toilets. We've got to plan them and implement them in an integrated manner that would also be providing social and economic development, within our city. Then as part of such program, we can then start to be planning basically, how do we deal with the issues of people that get evicted and people basically that need, alternative, accommodation. In a nutshell, Mr. Chair, all that I'm saying is that all that work basically then hinges on what we have said earlier on, that for us to be able to respond effectively on this, we need to do a proper data, gathering and analysis, knowing where the hotspots are, knowing where the problem areas are. And so the issue of data coordination becomes very important, in this regard. And then secondly, we are in full support that there's got to be meaningful partnerships and participation between government, cities, as well as civil society structures. I am encouraged now with the process that the National Department of Housing of Human Settlements has just entered into now, a framework between civil society organizations as well as the National Department of Human Settlements, where there's an agreement now for cities, for government to work collaboratively and strongly with communities, especially in informal settlements. And it's something that needs to be encouraged and also something that needs to be implemented, effectively, on the ground. And in closing, the cost of policy of eviction or being reactive to informal settlements upgrading, it's very, 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 very high. And also it can be disastrous as well. We have seen what has happened, in Cape Town recently. The reactive approach is costly, and it can also lead to lots and lots of problems. And we agree that a proactive approach to dealing with the issues of upgrading, citywide upgrading, and also alternative accommodation can be much more sustainable, and also will be one that can even start to be decreasing the land invasions that we see, in our cities through programs like managed land settlements, the provision, of service sites, and then promoting people, to be able to build their own houses on an incremental basis as well as sustainable basis. Thank you so much.
Thank you very much, Sis. I think you said a mouthful, but one of my biggest takeaways from the last point you raised is the data coordination, which I think is very useful in helping the cities to plan for these TEAs, because currently the cities are just dealing with these TEAs on an ad hoc basis, and as Sienna said earlier on, out of pure obligation, which is just causing a lot of problems on many levels. On that note, I think we should just address the questions. I'll ask the panelists to address the questions that have been shared on the screen, that have been asked by our attendees, and then we just can continue with the discussion on how TEAs can be developed better for the occupiers and what the city needs to do. So I'm not sure if the panelists are able to see the screen and the questions that have been posed to them.
I can see them. Am I allowed to perhaps start? Give it a shot.
Yes, please, Sienna.
Yeah. Perhaps I can try the bottom two, and they are linked. I guess the first two ones might be directed at SERI. So if I start with the last one, which says, to what extent is rural-urban migration at the moment contributing to this demand in the cities? You may recall, I think, both in Seth's input about the fact that there is this migration, there's this urbanization. I used some stats just to help us to visualize that that growth on housing demand. that if you consider that every year, Gauteng receives almost 300,000 new people. That means the demand for housing grows by 300,000. I think a few years ago it was said that in Johannesburg alone receives almost 100,000 per year. Now, when you develop an IDP and you plan for your housing, you plan on the basis of the numbers that you have. Seth made reference to the fact that there is some kind of scenario planning now that's starting to happen, predictive modeling. But that is based also on the stats that you have currently. And even the funding allocation is based on population, at least that we know currently. So 1 year into that 5-year plan, you have an additional 100,000 people if you're a city of Joburg. In the next financial year, you have another 100,000 and so on. Those additional people need houses. So that is the most direct link between that urbanization and the demand for housing and the difficulty of the cities to keep up with that demand. I like what the SERI is raising to our attention, that perhaps without denying people the right to move to the city, that perhaps you mitigate the urgency of their need by ensuring that there's a good quality of life even in the rural areas, such that they are not pushed into the city as a matter of necessity, but perhaps out of just chasing a different set of options than there are available in the rural area. It is in that context that that as different partners, we developed the Integrated Urban Development Framework. If you look at that IUDF, it highlights, of course, the need to develop and support urban areas in their different scales, metros, intermediary cities, and small towns. But also, unlike how we had viewed urbanization and urban development in previous times, as an antidote or as against rural development, the IUDF emphasizes that urban development is as critical as rural development, even if it focuses on one end of that scale. So that hopefully deals with that. You will not stop migration, it's a global trend, but at least you reduce the rate at which it happens. And in fact, some people even from the city might even want to migrate back into the rural areas, or at least into the smaller towns. The pro bono supports, I suspect it is being targeted at individual citizens who are on the receiving end of this difficulty. But if we are able to utilize that legal support in supporting municipalities to interpret what can and should be done and the consequences of what not to do, and refine their own instruments, because some of them need to be need to benefit from legal minds, we would certainly use that. There is a huge need even in the municipal environment, certainly at SALGA as well. But I'm just being opportunistic there because I almost suspect that that question is directed at the individual citizens. But if we agree that this problem needs to be resolved holistically, with all of us putting all hands on deck to deal with different parts of the problem, I'm sure we can work together even with those attorneys. Thank you very much.
Yeah, can I respond to the question from the anonymous attendee?
Yes, please.
Okay. I think she says that I've raised the issue of in-migration and asking if there is any thinking as part of the policy brief that speaks to managed land settlement. I think, as I indicated, that there is work, but it's more of a guideline work as well as our tools that was developed by Ephesus Copeland, which is an NGO very involved in informal settlements upgrading. they've done a lot of work on managed land settlements. In response to that, I am also aware that the Housing Development Agency, which is basically an agent of the National Department of Human Settlements, has developed some guidelines on managing and curbing unauthorized land, occupations. And as part of those guidelines, one of the tools that they are promoting basically to manage all these urbanization pressures, land invasions, and ensuring that we promote incremental and in situ upgrading in our cities, is that of managed land settlements. We have not seen the scale of managed land settlements in our cities. I know that when I was in PE as the head of human settlements, we did test the approach in terms of making land available and putting rudimentary services and allowing people basically, to settle as a way of managing, urbanization. But it's not something that our cities have really, scaled up. And I think all these tools basically are aimed at ensuring that the cities start to scale up, these managed land settlements. And my view is that once you start to focus on proactive managing land settlement, then in that process, you can easily then start to be planning through a data, coordination and integration process, identifying those people that would require, to be resettled or to be provided alternative, accommodation. Start to be planning, for such. And I can also report that myself and Lauren as well, we are also part of a reference team as well with a Housing Development Agency, where they are currently busy developing some land assembly as well as development, strategy for the Department of Human Settlements. And one of the proposals that we have also put very strongly across basically was that of managed land settlements. And there is a policy process that is underway at national government at this present moment. And it is my wish and my hope that this managed land settlement, approach will land positively and constructively, within that space in terms of policy, development. This is the type of enabling, a framework that I believe the municipalities as well as the city will require for them to be able to deal with these type of issues, of proactively providing, alternative accommodation, not in a reactive manner, but more in a proactive manner. Thank you.
Thank you very much. I think I'll answer the question from Mfanfigile about involving the Department of Health before the relocation. So in the relocations that SERI has done, we haven't involved the Department of Health, and predominantly because in most of these relocations, we've had to go back to court time and time again for the city to be ordered to ensure that the relocation happens very, very soon. So there hasn't been space to involve the Department of Health, which I imagine would be from within the city. And it may be something that we may want to look at in future evictions and future relocations, especially because now we have this COVID-19 pandemic, and it's very important to look at the quality of the alternative relocation sites in light of the pandemic. But so far we haven't involved the Department of Health. I think it's something we might just want to look at going forward. I'm not sure if Lauren will answer Sushila's question. Lauren, will you take the question from Sushila?
Okay, I'm sure you'll have something to add from litigation's perspective, but I think that the important point is the legal representation for occupiers is insufficient. So there are many occupiers who never get representation. So there's a very important role for pro bono attorneys in private practice to assist in regard. Furthermore, there's also a very important role in prior to going to court to assist in respect of meaningful engagement. And the purpose of meaningful engagement is to ensure mutually acceptable solutions. So I think there's a role there too. And then furthermore, the PI Act has a mediation section where I imagine pro bono attorneys could also play.
Thank you, Lauren. I think from a litigation point of view, I'm afraid I don't think there is a much more effective way without the litigation. What may be more effective for pro bono attorneys is in the litigation to ensure that in the papers you obviously put timelines for municipalities to comply and provide the temporary alternative accommodation. But from our experience, what has been the driving factor has been the property owners pushing the cities to provide alternative accommodation. And if it's just the occupiers, the push sometimes just isn't enough. So I think it really depends on all the role players in the litigation. And the litigation seems to be the only pushing factor against the city. And I think Sienna also mentioned this in his discussion, that it's only then that municipalities do it out of obligation. But other than that, even we as an organization have not been able to get the city to provide alternative accommodation, except for if there's obviously an act of disaster, as was the case with the building that was occupied by Usiabonga and other occupiers. It's only because of the fire that the city moved them into alternative accommodation. But other than that, would have had to continue to engage in the protracted litigation. So I think we've got 2 more questions, or 3. Ed is going to just put those up for our panelists to look at and just discuss and answer those questions. And I'll add where it's necessary.
Okay, so Kuliliwe, if I may, on Alison's question regarding a rental housing strategy, we do around rental, and in particular looking at, it's less a question of responding to occupation in the first instance, but obviously the supply of rental accommodation is an important option. Regarding the rental housing strategy, we are making some inputs around the norms and standards, and in particular, the need to consider what a fair rental regime should look like. So this really relates to where I turn off my video. But Can you hear me?
I can hear you, Lauren. I'm not sure if everyone else can hear
Hello?
you. Hi, Lauren, I can hear you.
Hi, Lauren. I think proceed. You are breaking a bit. I think it's slow internet,
Okay.
but yeah, do go.
Okay. Thank you. I hope everybody else can. My apologies for that too. Okay. Yeah, I was concluding a response to Alison Wilson's question with a comment about the importance of the rental housing strategy norms and standards and the establishment.
Lauren, we can't hear you. I think your connection is giving you problems. So while we wait for Lauren's connection to be better, I think I'll just add a comment to Sushila's further question in the Q&A chat box about the strategies that pro bono attorneys have tried to apply. So in our litigation, what we have seen to be useful and pushing the city, at least from the applicant's side, is it's when the city's head of housing is being forced to be personally liable for failure to comply with the order to provide TEA, and has really pushed the city to provide the TEA. So maybe that may be something that may be useful for pro bono attorneys and the applicants in the matters that you deal with. Of course, the solutions that applicants offer should not disadvantage the occupiers, because that's the last thing that people need. So Lauren, is the connection better? Can you hear us?
Yes, I can hear you very well. I'll give a go in responding to Mark's question, but if I do lose connection, I'll leave it to somebody else from SERI, and I will type a response in the box, in the chat box. Mark, the alternative accommodation is linked to relocation. But as you know, relocation is an option of last resort. We do, however, advocate for the provision of emergency services and interim services, and the provision of tenure security measures in situ prior to relocation, depending on the time frame for relocation. And as you know, a lot of our work is focused on advocating for the implementation of the upgrading of informal settlement program, which really sees in situ upgrading as the priority. We think, though, that what we have not sufficiently explored yet in the country is the in situ upgrading in the occupied building context. So there's a gap there. Thanks, Kuliliwe.
Thank you very much, Lauren, for that. I hope it answers the questions. If anyone still has further questions, I'll just ask that you put them in the Q&A box, and then we can address them. Otherwise, if we don't have any further questions, I think we'll just wrap up the webinar. So I'll just give people a few minutes to put on any last questions in the chat box, and then we can just conclude on this webinar.
We have 2 more questions, which I'm going to share now.
So I think I've tried to answer the second question, which was a follow-up question to Sushili's earlier question. The only question that is left for us to answer is Mark's question. I'll just ask Alana to take a go at this question, and then I can just add if there's anything that she wants me to add from the litigation's point of view.
So you're not talking about Mark Misselhorn, because I think that Lauren did respond to Mark's question.
No, there's a second question that Ed has shared on the screen.
I mean, I think this is a question that really should be directed to municipalities. Like, what measures are there in place to fast track alternative shelter? I mean, if they have the the legal obligation, and I think that's not something that we can comment on. What we're saying is a proactive plan and national framework is needed to ensure that there is a proactive programmatic approach to this.
Thank you, Alana. Seth and Sienna, can you take up the question for us?
Yeah, I'll build on to what Alana is indicating about the need for a national approach, a national framework. Now, you will recall that my point of departure is that a litigious posture based on the laws, the regulations, etc., will help up to a certain extent. What we do need is to build the internal capacity to plan, budget, and execute those alternative accommodations. And it's a function of exploring different housing opportunities. And there were some suggestions that included rental accommodation, informal settlement upgrade, etc. It is our ability to fast track those short as well as medium-term alternatives that will get us there. Many of them are there in policy, many of them are there in plans. The technologies are available. The services, delivery of water, waste, health requirements. It is really a matter of how to overhaul a system to knit all of that together. And I guess for me, it's a point I'm making that we need to work together. And I've offered SALGA to work with SERI to continue to provide the support to municipalities on how best to go about it.
Thank you very much. Hopefully that answers Mark's question.
May I just add something, Kuliliwe?
Yes, of course, Lauren.
I think that one of the important points about a proactive approach is being able to predict. And in our engagements, in the last round of engagement we had with SALGA in 2016, many municipalities said, well, how can we predict emergencies? And our approach, and I think it's what both Sienna and Seth have spoken into, is that understanding us. We're not suggesting we plan for evictions, we're really suggesting that we plan for homelessness. It's not semantic, I think it is an important distinction, but we do think that it's possible to make some, including the need for relocation. So in that sense then, it in part addresses the speed concern. But the other question I think is to look at, from a planning perspective, at how zoning can assist. So how special zones or transitional zones or informal settlement zones can be declared with regulations attached to them that permit addressing or overcoming some of the inhibiting regulations, norms and standards. Thank you.
Yeah, I can also just quickly add, I hear what Mark is saying, that we've got a plethora of laws, regulations, and standards, and measures and opportunities to fast track, to fast track alternative emergencies. I'm not seeing the full questions, but I'm just getting the gist of the question because there's something that is blocking me on my screen. But the question is really is it a good thing to be having lots of laws and regulations and norms and standards, or just to be having just one law? For me, it's my personal view is that with the plethora of laws, this then gives you, like, for instance, some kind of flexibility in terms of how do I start as a municipality, to be looking at those relevant pieces of legislation or regulations that can enable me, to accommodate, alternative accommodation within my policy as I'm developing the policy, because this is a space which is evolving. And I think the invitation that Sienna is giving from SALGA, saying that, guys, we would like to work with you, as SERI and to engage the municipalities. I think it will be within that plethora or that broad framework of regulation and laws that we can say, guys, within this broad, how can we really start to be addressing? I mean, we've got lots of EHP is one of the policies. We've got URSP. We've got lots of laws, policies, and programs. And we need to be flexible within that space. I'm not saying that things are going to be easy, but at least we can try to innovate and to be creative, within that, broad space. And I think the toolkit that I spoke about as well, that we developed, as the city support program, it also tries basically to help the metros to say, how do you navigate between these laws and regulations now to be able to attend to the issues of informal settlements upgrading in a more programmatic and citywide scale, and not to be reactive, but to be more proactive. I'm more looking at a broader upgrading, looking at it in an integrated way, dealing with the current situation, and how do you also basically, as the city, to be ahead of our game, because the cities are not static, they are growing. How do we deal with the growth that is taking place, within our cities? How do we, we've been talking about, like, for instance, when I was in Cape Town at some point, that how can we work and develop what we call reception, areas? But you find that sometimes these things are doable, but politically there is just no will, to really start to be piloting and to be implementing these innovative ideas. I think it's time now that within the framework, within policy, and within using our tools, we can really start to pilot some of these, methods, that we've been discussing over the years. Thank you.
Thank you, Seth, and everyone who has been part of this webinar. I think one of the biggest takeaways from this webinar is that we need to have more discussions with the cities on how we can improve the provision of alternative accommodation that we're having, how we deal with a lot of numbers, the backlog that the cities have, because it's all well and good to have the legislation, the jurisprudence on this, but if there's no political will, like Seth has said, we find ourselves stuck in all of this litigation where we often have to go back to courts to force the cities. And even then, the cities just do provide the TEAs out of being forced, and then we have more problems as people have been relocated. And to avoid that, maybe if we have proper discussions and try and get political will from the cities in where the alternative accommodation sites are concerned, maybe we might find a better solution. And on that note, if there's nothing further from our panelists, I think I will just conclude this webinar. Thank you, everyone. The policy brief is available. We've shared the link on the chat box, and it's also available on our website. Thank you very much.
Hasta de repente.